Welcome to The Explainer. Today, we're diving into a deeply human, documentary-style case file that exposes exactly what happens when a vulnerable family goes head-to-head with a rigid, unforgiving bureaucracy. We are unpacking the case of Poinsett County Housing Authority versus Reese Freeman. And right up front, I need you to know, this is not your typical, everyday lease dispute. This is the story of a single father of three fighting tooth and nail to protect his family from an unjust eviction and figuring out how to leverage federal law to hold a broken system accountable. The human stakes here, they're incredibly high. In Reese's formal request to the Housing Authority, he made it abundantly clear that a minor in his household, his own child, has documented epilepsy. We have to remember that housing stability in this context is not just some minor administrative detail. It is an absolute medical necessity, because environmental stress and the chaos of instability directly impact the management of severe seizures. Just think about what it takes to be the sole custodial parent for 3 kids while managing a severe medical condition. Reese carries an immense weight every single day. We're talking constant seizure supervision, strict medication monitoring, and making sure he's capable of rapid emergency response. Plus, his current home is just 2 blocks from his kid's school and 1 block from a pharmacy. Being forced out of this specific location literally threatens his ability to keep his child safe. For this family, a stable home is a lifeline. Section 1. The compliance trap and creating a false narrative of failure. So, right out of the gate, there is a massive contradiction at the heart of the Housing Authority's case. The Poinsett County Housing Authority, or PCHA, officially alleged in their notices that Reese failed to complete his annual income recertification. They basically set a legal trap to evict him. But the reality? It's completely different. Reese had actually submitted his disabled child's supplemental security income documentation to the housing clerk back on January 15th. And the smoking gun proof is an email from Tina, the PCHA housing clerk, dated January 16th. In it, she clearly writes, "I've completed your annual recertification," and she goes on to explicitly adjust his monthly rent to $136.00 beginning February 1st. But here is the truly astonishing part. PCHA went ahead and filed the massive 86-page court complaint against Reese, claiming he didn't recertify, and they completely hid this exonerating email from their filing. Moving on to Section 2, the remediation and outdated photos, the cover-up of Reese's compliance. Let's trace the timeline here, because it's wild. PCHA issued an eviction notice primarily based on yard debris and porch clutter. Okay, fair enough. But by March 17th, Reese formally notified PCHA that he had completed about 75 to 80% of the cleanup. He put in massive physical labor to fix the issue, all while juggling those intense caregiving duties. A grievance officer even issued a conditional decision in April asking for the complete cleanup. But instead of actually sending someone out to verify his progress, PCHA just filed a lawsuit for unlawful detainer months later, in June. Which brings us to a huge, glaring question. When they finally went to court, why did PCHA hand the judge printed paper copies of an old, messy yard while actively hiding the original digital photo files? Well, it all comes down to XF metadata. When you snap a digital photo, the file permanently embeds the exact date and time it was taken. By handing the judge black and white printouts, PCHA was presenting a completely outdated version of Reese's yard, likely from February or March, way before he did that massive cleanup. Without those native digital files and the metadata attached to them, Reese was robbed of objective proof showing that the Housing Authority's pictures were totally misrepresenting the actual, heavily remediated state of his yard at the time they sued him. All right, on to Section 3, the ignored accommodation, bypassing the Fair Housing Act. Now, you might be wondering, what does federal law have to say about this? Federal law, specifically the Fair Housing Act and Section 504, mandates a very strict process when a tenant requests a reasonable accommodation for a disability. Once a formal request is submitted, which Reese actually did via certified mail delivered on May 8th, the housing agency is legally required to engage in an interactive process. They have to evaluate reasonable alternatives to literally throwing a disabled family out on the street. And to be clear, Reese was not asking for some kind of permanent free pass to break lease rules. He submitted a deeply detailed, legally protected plea based entirely on his child's epilepsy. He just asked for a temporary administrative pause on the eviction, a final current inspection of his newly cleaned yard, and a chance to prove his ongoing compliance. He was just begging them to look at the real current condition of his home before displacing a medically vulnerable kid. But here is the truly heartbreaking reality of this case. PCHA completely ignored it. They received that certified mail packet on May 8th, and did nothing. They never issued a written approval. They never issued a denial. They never even asked for more medical information. They completely refused to engage in any interactive process whatsoever. Instead of doing their mandatory federal duty, they stayed silent, turned around, and dragged a single father and his disabled child into court. Let's dive into our final section, the federal discovery violation. This right here is Reese's ultimate legal shield. Knowing he was being railroaded, Reese actually fought back using the law. He formally demanded that PCHA hand over the original digital photos and his complete tenant file. He submitted an expedited notice of non-production and motion to enforce a very specific federal regulation, 24 C.F.R. Section 96.4M. Now, PCHA's attorney acknowledged this request on July 24th, but produced absolutely nothing before the immediate possession hearing scheduled for August 6th. You have to understand the sheer power of this specific federal regulation. It is an absolute mandatory protection for public housing tenants. It states, in black and white, if the PHA does not make documents available for examination upon request by the tenant, the PHA may not proceed with the eviction. It doesn't get more unambiguous than that. If a housing authority hides relevant defense evidence, their right to evict is instantly paralyzed. When you compare what the law mandates against what PCHA actually did, the compliance gap is just stark. Federal law mandates pre-hearing disclosure. PCHA offered total non-production. Federal law requires preserving digital metadata. PCHA refused to provide the files and relied on those old printed photos. Federal law dictates the PHA may not proceed with the eviction. PCHA arrogantly scheduled the immediate possession hearing anyway, in total defiance of the rules. So, by burying that January 16th recertification email, by withholding the EXIF metadata that would prove the yard was actually cleaned, and by hiding the records of a completely ignored reasonable accommodation for a disabled child, PCHA didn't just make a little paperwork error. This was a systemic cover-up that, under federal law, legally invalidated their entire eviction attempt. Which leaves us with this final, really provocative thought. If a public housing authority feels bold enough to actively hide exonerating emails, withhold digital evidence, and entirely bypass the Fair Housing Act just to evict a single father and a child with severe epilepsy, who is actually holding this system accountable? If Reese Freeman hadn't researched the law, fought back representing himself, and demanded this level of documented proof, what in the world would have happened to his family? Thank you so much for joining me in this explainer. Keep questioning, keep learning, and I'll catch you next time.